and judges of the Caribbean Court of Justice,
The Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana. Hearing of the appeal in the matter GYCV2023-004 between Xi Jinping and Zhao Guangzhou against Guyana Power and Light Incorporated. The members of the hearing panel are the Honorable Mr. Justice Saunders, President and Presiding Judge, the Honorable Mr. Justice Anderson, the Honorable Madam Justice Rajnath Lee, the Honorable Mr. Justice Barrow, and the Honorable Mr. Justice Burgess. Counsel, you may now enter your appearances.
Good afternoon, Madam Registrar. Thank you very much. Good afternoon, Honorable Justices of the Caribbean Court of Justice, Honorable President, Justice Saunders, Honorable Justice Anderson, Honorable Justice Rajnath Lee, Honorable Justice Barrow, and Honorable Justice Burgess. My name is Stephen Fraser, Your Honors, and I appear for the appellants, Xi Jinping and Guang Zhao. Appearing with me this afternoon is Ms. Chantal Scott Lal. Thank you very much, Your Honors.
Yes, good afternoon, Counsel. And for the
Good day, Your Honors. If you please, my name is Tim Jonas. Ms. Crystal Tuana Abrams is with me, and we appear for the Respondent, Guyana Power and Light, Inc., with your permission.
Yes. Are you ready to proceed, Mr. Fraser?
Yes, please, Your Honor. Your Honors, the issues before the court this afternoon are whether Regulation 31(2) of the Public Electricity Supply Regulations as amended applies to limit the respondent's claim by way of civil action for electricity consumed to a period of 12 months back billing, or on the other hand, whether the words in Regulation 2, without prejudice to public suppliers' rights under any other provision of the Act, these regulations, and any other law or legal principle, allow a claim by civil action on the part of the supplier for electricity consumed in excess of a 12-month back billing period. The appellants contend, Your Honors, that the respondent's claim against them, brought as it is by civil action, is restricted to a 12-month period, billing period, in accordance with the provisions of Regulation 31(2). In support of our contentions, Your Honors, it is respectfully submitted that the statutory provisions of the Electricity Sector Reform Act, those of the Public Electricity Supply Amendment Regulations 2010, and those of the Standard Terms and Conditions expressly apply, and together they import the 12-month restriction to back billing insofar as the claim is brought by civil action. The statutory provisions on which we rely, Your Honors, we may separate into primary legislation and secondary legislation. For the primary legislation, Your Honors, we intend to rely on sections 21, 22, 23, 24, 25, and 29 of the Electricity Sector Reform Act. It is respectfully submitted, Your Honors, that save in the instance of a special contract under Section 29 of the Electricity Sector Reform Act, the provisions outlined are inconsistent with an ordinary common law contract. If we may, Your Honors, just briefly, Section 21 of the Electricity Sector Reform Act provides that, subject to the provisions of the Act and any regulations, a public supplier shall, upon being requested to do so by the owner or occupier of premises, provide a new or increased supply of electricity. If we may pause and just emphasize, Your Honors, in describing the owner or occupier of the premises, the legislation is careful to identify that thereafter or hereafter in the legislation, the owner or occupier of the premises will be described as the consumer. And thereafter, throughout the legislation, the word consumer appears, except in the case or except in the standard terms and conditions document. Section 22, Your Honor, provides the manner in which a consumer requiring a supply of electricity shall give the public supplier notice. Fills up, it seems like a very simple notice, and only 4 items are required. First, he must identify the premises. Secondly, he must identify the date of commencement of the service. Third, he must identify the maximum power required. And fourth, the maximum period for the supply, the minimum period, sorry, for the supply of electricity. Section 23, Your Honors, which we respectfully submit as a very pivotal section. Section 23 provides that upon the receipt of the consumer's notice, the public supplier shall in turn give the consumer notice specifying a number of particulars. First, Your Honors, the notice must specify which of the proposals in the notice, which of the 4 proposals in the notice are acceptable. And the public supplier may specify counter proposals in his notice. Second, the public supplier must specify whether the rates charged are the prescribed rates or whether the rates are to be determined by special agreement under Section 29 of the Electricity Sector Reform Act. If the rates are prescribed, Your Honors, then there is absolutely no room for negotiation or discussion in respect of the prescribed rates. Next, Your Honors, in that notice, the public supplier will dictate the payment for the lines, meters, and other apparatus which are necessary to commence the service. It also prescribes the security deposit that the consumer would be required to pay. And then there's an omnibus clause.
We could follow through all of those on the thing. What is the point that you make on those bits of statute? Of the statute?
Well, particularly in relation to Section 23, Your Honor, it provides for the creation of a contract for supply of electricity. The concluding paragraph of section 23 provides that on the exchange of the notices between the public supplier and the consumer, that shall constitute a contract between the consumer and the public supplier for the supply of electricity in accordance with the Act and the regulations thereunder. And we pause to emphasize, Your Honors, that the contract for supply of electricity is that is strictly in accordance with the Act and the regulations. The legislation, Your Honor, which we outlined, is very similar and may have been patterned off of the UK 1989 Electricity Act. The provisions were considered in detail in the case of Norweb against Dixon. It's a 1995 case, 1 WLR 636. Both parties have referred to that case, and both parties, I dare say, rely on it to different extents. In relation to the provisions, Your Honor, Justice Dyson identified that those provisions in no way are indicative that a contract was consumed or consummated between the parties. And he says at page 643, letters F to G. The issue in this case is which side of the line does the relationship between a tariff customer and a public electricity supplier fall? In my judgment, the legal compulsion as to both the creation of the relationship and the fixing of its terms is inconsistent with the existence of a contract. As regards the creation of the relationship, the supplier is obliged by section 16.1, the equivalent in Guyana is section 21, to supply if requested to do so. The exceptions from the duty to supply provided in section 17, the equivalent of our section 24, are very limited in scope. Counsel for the supplier in Norweb, Your Honors, further persisted that the supplier had a discretion not to supply electricity to the consumer. Once again, Justice Dyson rejected this consumer. And he says at page 64, letters G to H, that's not so. That is not so, sorry. A supplier is excused from supplying if, the burden being on him, it is not reasonable in all of the circumstances for him to be required to do so. What is reasonable is a question of fact to be established objectively. Discretion does not come into play. Thus, save in certain narrowly defined circumstances, if a consumer requests the supply of electricity, the supplier is obliged to supply. The accepted circumstances can be found in our section 24 of our Electricity Sector Reform Act. Yet still, Your Honors, counsel for the public supplier in Norweb persisted further that there was scope for bargaining on the terms of the supply. And Justice Dyson replied at page 643, so 644, 643H to 644A, that I cannot agree. The tariff is fixed by the supplier, and he refers to section 18, or equivalent section 23B. The supplier can require the consumer to defray any expenses reasonably incurred in supplying any electric line or plant. He refers to section 19, the equivalent of our section 23C. And to give reasonable security, refers to section 21 of the UK Act, the equivalent of our section 23D. The supplier can also impose additional terms of supply. Again, refers to the United Kingdom section, or equivalent is section 23E. And then he continues, the consumer has no bargaining power in relation to these matters. It seems to me that the principal terms are imposed on the consumer by the supplier, not as a result of any bargaining, but by the supplier exercising the power conferred on it by the Act. Respectfully submit, Your Honors, that that is the same position that attends to the Electricity Sector Reform Act in Guyana. We note, Your Honors, that Counsel for the Respondent accepts the conclusion that the statutory obligation imposed on the customer to pay a bill is a statutory debt, even if the relationship was not, strictly speaking, contractual. Your Honors, you would find that statement or admission by counsel or by the respondents at page 586 of the record at paragraph 3. And these would be the updated submissions filed by the parties. Your Honors, in view of the Norweb decision and in view of the respondent's concession, it is respectfully submitted that the relationship between the parties is purely statutory. And this is emphasized by Section 23 of our Electricity Sector Reform Act, which provides that a contract is created in accordance with the Act and the regulations. The marginal note, Your Honors, to our Section 23 is contract for the supply of electricity. In consequence of our first submission, Your
Mr. Fraser.
Yes, please, Your Honor.
Is it possible to have a contract with statutory implied terms?
Yes, please, Your Honor.
So why isn't it possible to interpret Section 21, I think you pointed from there to Section 24 as an invitation to treat an offer, and then an acceptance of the offer, which is classical contract. And
yes, please.
Yes, and bargaining is never present in consumer contracts. Take, for instance, your standard hire purchase. If you look for bargaining there, it is accepted all around that bargaining is no part of that. They actually refer to as adhesive contracts. So what I don't understand is everything in the sections that you have read point towards all the elements of contract, offer, acceptance, consideration. But the contract is subject to statutory implied terms, isn't it? Isn't this a way of looking at it? The Norweb case, has it been followed?
Well, we have not been able to find an authority that expressly adopts, but we have found another case, decision of the Privy Council, which sort of inferentially adopts the same position. But Your Honors, in relation to the contract and inferentially, the reason why we mention specifically Section 23 and the fact that it prescribes the contract for the supply of electricity as being bound by the regulations and the Act is to emphasize that the relationship which has been outlined in the in the Norweb case, applies to Guyana, especially so since in Guyana, we actually have a provision, that's Section 23, the last paragraph, which pronounces that upon the exchange of notices, a contract is formed, and that contract is subject to the act and the regulations.
What I don't understand fully is how is the contract formed and then an assertion can be made that there's no contract? The section clearly says that there's a contract made,
Yes, please, Your Honor.
made on certain terms.
Yes, please, Your Honor.
And this is not the only area in which you have statutory implied terms, where terms which are in the statute are imposed on the contract. So I'm not clear in my mind, respectfully, I'm not clear in my mind as to the basis on which you're saying there's no contract. Norweb, the case which you are referring to, I wonder what's the authority of that case. It certainly doesn't bind us, but what is the authority of that case? Has it been followed?
I indicated, Your Honor, that we have been unable to locate an authority that applies Norweb, directly applies Norweb.
Thank you.
But in relation to the contract, Your Honor, we respectfully submit that insofar as the contract is in the terms prescribed by the Electricity Sector Reform Act and the regulations, although the Norweb points in that case, because there was no similar provision as our Section 23, although the Norweb case points to the fact that there's no offer and acceptance and those things, we in Guyana must accept that there is a contract, but a contract for the supply of electricity as specifically and expressly provided by Section 23. We would like, however, to rely on Norweb insofar as it emphasizes that the terms of the contract are prescribed by legislation, and as the Learned Justice Dyson says at some time, that the terms are imposed on the consumer. But I go further, the terms are imposed on both parties, the consumer and the supplier, by legislation. We would like, Your Honors, to submit that whether or not the relationship between the parties is one of contract or, as Norweb says, a purely statutory relationship. For the purposes of the Electricity Sector Reform Act and the regulations thereunder, the effect is the same.
Mr. President, I'm just for clarification, the Norweb case, was it interpreting a section similar to Section 23? Was it based on a section similar to Section 23 in the Guyanese Act?
No, please, Your Honor.
Well, that's what I thought.
That is the distinction. That is the distinction between the Norweb case and our situation in Guyana.
So how can we rely on it to interpret Section 23 if it doesn't make contact with the wording of Section 23? Because Section 23 is pretty clear. Shall
Yes,
constitute
please,
a contract.
A contract. Yes, please, Your Honor.
Thank you.
But Your Honor, yes, please, Your Honor. But there are two aspects of it. One, the consumption, and the other one, a contract. Which we will come to, Your Honor, when we get to the regulatory provisions. Because our respectful submissions is that the regulations, as in the case of the primary legislation, is also mandated or mandatory. They're imposed by the Electricity Sector Reform Act, as well as the Public Electricity Supply Amendment Regulations and the standard terms and conditions. The regulatory provisions, Your Honor, and with the court's leave, we'd like to address them briefly. The regulatory provisions, Your Honor, are imposed by two documents: the third schedule, which constitutes the public electricity supply regulations, as well as the document which is attached to the license, the standard terms and conditions. Where the documents cover the same field, the provisions or the conditions of the standard terms and conditions prevail. Your Honor, both the respondent and the appellants recognize that their claim is brought under regulation or under standard terms and condition 7.5. The standard terms and conditions 7.5, condition 7.5 provides that the customer is liable to the company in accordance with tariff schedules for payment of accounts for all electricity consumed or estimated to have been consumed on his premises or on foot of a contract for supply of electricity. It is respectfully submitted, Your Honor, that on foot of a contract for supply of electricity refers to the contract that is created under the final paragraph in section 23 of the Electricity Sector Reform Act. Accordingly, Your Honors, and if I may return to something that we said earlier, that we submitted earlier. Accordingly, Your Honors, it is respectfully submitted that liability under condition 7.5 can arise either from the consumption of electricity on the premises or from or on the foot, to use the terms of the regulation, or on the foot of a contract, which would be the section 23 contract for the supply of electricity. This brings us, Your Honors, to the Public Electricity Supply Amendment Regulations 2010. Regulation 31.2 provides inter alia that the public supplier may recover in a civil action from any adult person. I pause at that part, Your Honor. I propose to look at the regulation sectionally. Recover in a civil action. Your Honors, it is our respectful contention that the claim that was brought initially is a civil action. And I do not believe, Your Honors, that it can be described as anything else other than a civil action. Regulation 31.2 further provides that the public supplier may recover in a civil action from any person occupying premises at which electricity is or has been abstracted, diverted, stolen, wasted, consumed, improperly registered, or otherwise used, but not paid for. We respectfully, Your Honors, would like to emphasize that recovery here specifically addresses electricity consumed or otherwise used, but not paid for. Under the, respectfully, Your Honors, under the respondent's statement of claim at paragraphs 4 and 5, which could be found at pages 192 and 193 of the record, I believe and I may be characterizing here, but I do believe that the claim that was brought by the respondents should be described and can be described as being brought under a contract for supply of electricity. That is the Section 23 contract for the supply of electricity. If that is so, Your Honors, because the alternative, bearing in mind that it is brought under STC 7.5, the alternative would be for electricity consumed. But assuming that it is brought under contract for the supply of electricity, it is respectfully submitted that Regulation 31.2 encapsulates that claim as well. We've already established, Your Honors, that it is a civil action, or the action that was brought is a civil action. That is one limb of the Regulation 31.2. The second limb of the Regulation 31.2 is that the claim must be, or can be, amongst other things, for electricity consumed or used or otherwise used but not paid for. It is our respectful submission, Your Honors, that the claim on the foot of a contract for supply of electricity made under Section 23 falls specifically within the catchment area of the phrase electricity used, otherwise used, sorry, but not paid for. There, of course, is the alternative argument that the Section 23 contract can also be viewed under the other limb, that is electricity consumed but not paid for, because of course the electricity would have been consumed under the contract for supply of electricity specifically created under Section 23 of the Electricity Sector Reform Act.
Mr. Fraser, could you help me here?
Yes, please, Justice Barrow.
In your submissions, where do I find this thesis which you are now propounding?
In our submissions, please, Your Honor. Your Honor, our submissions, if you allow me a second, please, Your Honor. Yes, please, our submissions are, our submissions are all addressed to the issue of the Regulation 31.2,
right,
encompassing or being limited to the 12-month limitation,
right,
in respect of back billing.
yes,
That is the entire thrust of our submission, and that we claim, or we submit, Your Honor, that the words consumed or otherwise paid for are the words which contribute, or the words which bring the respondent's claim within the parameters of Regulation 31.2.
right.
That is and has been our submission.
So
Today,
yes, please continue.
Today, Your Honor, we are merely explaining, if I may, we are merely explaining how is it the claim under standard term and condition 7.5 falls to be considered under 31.2. Because the wording in regulation or standard term and condition 7.5 are exactly the same in relation to consume, and insofar as it speaks to a contract for supply, the section 23 contract, and regulation 31.2 speaks to electricity consumed or otherwise used but not paid for. Our respectful submission is that on either of those two heads, whether the contract for the supply or consumed on the premises, on either of those two heads, the claim by the respondent is caught by the provisions of regulation 31.2.
And the other side had submitted that they were not bringing a claim under 31.2, but they were bringing a claim under the contract. Yeah?
Yes, please, Your Honor.
And their submissions took us through sections 22, 23, 24, etc.
Yes,
And
please,
I
Your Honor.
confess that I have had the greatest difficulty in finding where in your submissions there is any reference to these. Could you help me?
To 22, 23,
Right, right.
to the Electricity Sector Reform Act, Your Honor.
Yes.
Well, Your Honor, if I may recall, we may not have specified as we have in detail here. And the reason for that, Your Honor, is that we relied on the case of Norweb, which deals specifically with legislation that is similar to ours, so that we did not specify or we did not go through the legislation in the detail that we have here. However, we did refer to it.
No, Mr.
In
Fraser, what this is, you see, this is why I'm seeking your help. I see Norweb dealt with at paragraph 10 of your submission. The relationship
please,
between the
Your Honor.
parties is governed by statute. But
Yes, please, Your Honor.
I still don't see sections 22, 23, 24 mentioned being treated, etc. So I'm just wondering if you are treating us to some new dimension of your case. I know that you tend to be freewheeling in the matters you consider yourself able to argue. Is this another instance of that?
No, please, Your Honors. If I may guide you to page 608 of our submissions, and these would be the submissions in reply,
Paragraph.
Your Honor.
What paragraph in the submissions? I have the submissions before me, you see.
Yes, please, Your Honor.
What paragraph?
This would be paragraph 11 at page 608.
Right.
Yes, please, Your Honor. And we refer there, Your Honor, to a submission that would have been made by the respondent. And the respondent sketched an argument in answer dated 25th May to the Court of Appeal on the subheading contractual versus statutory debt, an unnecessary issue. The respondent unambiguously submitted that ESBRA created the right to sue, and the fact that the transaction constituted a contract under Section 23 ESBRA does not detract from the fact that it is a statutory debt.
Sorry, hold on. I have paragraph 10 of your submissions in front of me, paragraph 11.
Yes.
And you say that you are reading from what are you reading from, Mr. Fraser? You really need to help me.
Paragraph 11, sir.
Yeah, the incident of the statutory contract for the supply, etc.
Your Honor, I believe this is in relation to the updated submissions.
Yes.
Are those your reply submissions, Mr. Fraser?
Yes, please, Your Honor.
Or you are submitting from your reply submissions now?
No, please, Your Honor. You asked in relation to where there was discussion of section
Right,
23.
right.
Yes, please, Your Honor.
And I'm trying to find it in your adjusted or updated submissions,
Yes, please, Your Honor.
which, as I understand it, I'm looking at the document. As you
Yes,
say,
please,
they're
Your
at
Honor.
page 597 to 604 of the record, etc.
Yes, please, Your Honor. And then we go on to the submissions in reply. Your Honor,
I see, sorry. You see why you have left me?
yes, please, Your Honor.
You are responding, sorry, you are replying to a
Yes, please,
response
Your
which
Honor.
we have not heard presented yet.
Yes, please, Your Honor. I was only identifying, though, Your Honor, where discussion of section 23 of the Electricity Sector Reform Act arose. And I was only using...
I will try to catch up after the hearing because obviously the way how you are proceeding just has me totally confuddled, but do forgive me and I'll try to catch up. Go ahead.
As it pleases, Your Honor, and forgive any lack of clarity that arose therefrom.
So, Mr. Fraser, the reference you have made to, is it section 23?
Section 23, please, Your Honor.
Right. Now that relates. You're trying to explain, if I understand you correctly, why you say 31(2) is in play to
Yes, please, Your Honor.
limit what can be recovered. Am I right?
That's correct, Your Honor.
Okay. Taking that as it stands, though, what about the opening words of 31(2)? Because
Yes, please,
those
Your Honor.
are without prejudice to a public supplier's rights under any other provision of the Act, these regulations, any other law or legal principle. So in
Yes,
other
please,
words,
Your
the
Honor.
GPL can rely upon other provisions of the Act, other provisions of the regulations, any other law or legal principle. And that
Yes,
is
please, Your
what,
Honor.
as I understand it, the GPL is seeking to rely upon. So in
Yes,
other words,
please, Your Honor.
your discussion about the relevance of 31(2), accurate or not, as far as they are concerned, as I understand it, is completely irrelevant because
Yes, please, Your
they are
Honor.
not purporting to rely upon 31(2). So
That's correct, Your Honor.
why are you treating us then to this discourse on 31(2)?
Well, Your Honors, if I may, the reason why we are treating you, or the reason why we are dealing with section 31(2), we dealt with the limitation, or we had started to deal with the limitation. And we were...
Just a minute, listen. You weren't dealing so much with limitation as much as you were suggesting that the only basis on which the GPL could recover monies was a statutory basis that, well, you could use the word limited them to 1 year. Is that correct?
Yes, please, Your Honor.
But they were not seeking to ground their case in statute. They were bringing
That's
a
correct.
case in breach of contract. And
Yes, please, Your Honor.
your response to that is that there is no contract, or that they ought not to be able to ground their case in contract. There is only a statute, and that the only recourse that they could use is what the statute provides, and that limits it to 1 year. Is that your case?
Your Honors, our case is not as Your Honors, Honorable President, is not as has been described. What respectfully, Your Honor, what respectfully we are submitting is that despite the fact, and this is in relation to the question about the without prejudice, is that despite the fact that they claim to come under the without prejudice provision, that without prejudice provision is contained in Regulation 31(2) in any case. So that for them to claim that their civil action, which was commenced after 2010 or after these regulations were brought into force, it was commenced without reference and outside of Regulation 31(2) could not be accurate because they depend on the without prejudice provisions of 31(2)
Why do you say
to
they're
claim
dependent?
a
Why,
platform.
just a minute. Why do you say they are dependent on 31(2) for this action? Why couldn't they just bring a case in contract?
Your Honor, they could bring a case in contract, but the contract which they would have been bringing the case on would have been the Section 23 contract for the supply of electricity. So having brought the case for the Section 3 contract for the supply of electricity, our respectful submission is that it falls right into the breaches of Regulation 31(2) in respect of the fact insofar that it is a civil action, and secondly, it is a claim for electricity that was otherwise used but not paid for. Now, Your Honor, whether that claim arises by breach of contract or whether that claim arises based on the regulation that is just a statutory debt or not, our respectful submission is that the essential elements of Regulation 31(2) have been activated. Those essential elements haven't been activated.
And
They,
what has triggered those? What has triggered that activation?
the fact, Your Honor, that the claim brought is a civil action, and secondly, that it is for the recovery of money or the recovery of the value of electricity consumed or used, but not paid for.
But
That
Mr.
is a claim.
But Mr. Fraser, further to the question which my brother Anderson raised with you, doesn't Regulation 31(2) accept or exempt a breach of contract in effect from the operation of that regulation by the use of the word without prejudice to any claims, as the President has said, that you may have in contract? Doesn't that exempt a contractual action from the operation of Regulation 31(2)?
Respectfully, Your Honor, we do not believe so.
So
Because
what is meant?
because
I don't want to repeat my brother Anderson, but what is meant by without prejudice to legal principle? What is meant by that?
without prejudice, Your Honor, in the context of 31(2), refers to several other remedies that the public supplier has in support of his claim, either to recover money or to pursue stolen sums or to pursue an unregistered meter. There are several statutory provisions, and I presume common law provisions, by which the electricity supplier can pursue those targets which are expressly set out in Regulation 31.2. So that with respect, the without prejudice does not necessarily address the issue of a non-statutory claim.
Mr. Fraser,
The statutory,
you're saying that they can only bring a statutory claim. That's what you're saying.
for the recovery insofar as the sum is incurred.
Hold on, that this claim which they have brought could only have been a statutory claim. That's your thesis?
Yes, please, Your Honor, insofar as it falls within the express provisions of Regulation 31.
No, with the greatest respect, you are just adding something. Insofar as it falls within, they are saying we did not bring a contract, a claim under 31.2. How can you turn around and say insofar as it does? You have to be saying that any claim they bring must be 31.2, otherwise they can't bring it. Isn't that what you're saying?
Your Honors, yes. In these circumstances, yes.
Okay, I got you now.
That is, yes, please, Your Honor.
All right.
It must, yes, it must be within 31.2.
Otherwise, no
But, Your
contract.
Honor,
Otherwise, no
beg your
contract,
pardon,
no
Your Honor?
cause of action.
The cause of action, Your Honor, is for, on the contract, is permissible under 31.2.
That's what, Mr. Fraser, please don't dance with me.
No, please, Your Honor. I don't think that I'm dancing here. Because I think that,
Mr. Fraser, I put it to you, you agreed with me, and now you want to do some other steps. 31.2, you are saying, is where they are confined to. They can only bring a contract pursuant to 31.2, and that limits them to 12 months.
yes, please, Your Honor.
They are saying we brought a claim and we did not bring it under 31.2. We brought it
Yes, please,
under
Your Honor.
a contractual relationship other than 31.2. And you are saying that is not permissible. End of story.
If I may say so, we are saying specifically that insofar that it is brought under the Section 23 contract, that claim is cognizable under Regulation 31.2.
Mr. Fraser, don't do this to me. It is cognizable under. Whether it is cognizable under or not, they are saying we did not bring it under that. So
Yes,
why are
please,
you
Your
telling me
Honor.
about cognizable under?
Well, Your Honor, they say that it is not brought under that.
Right.
But our
Right.
Yes,
our
ma'am.
respectful submission, Your Honor, is that although they say so, when you look at the claim that they have brought, it falls within the statutory prescriptions.
Okay.
And the recovery that is sought falls within the statutory prescriptions. And therefore, the limitations apply. Were this not so, Your Honor, it would mean that the public supplier can bring an action against person A on the 31.2 with the limit being 12 months, and then proceed against person B outside of the Regulation 31.2 for 10 or 15 years.
But isn't that possible if, because you may not have had a contract with person A. Person A may have
Yes,
illegally gotten a connection from a light pole.
yes, please, Your Honor.
And so the GPI would not have had a contract with that person.
Yes, please, Your Honor.
So I don't understand.
But in this case, yes, but in this case, Your Honor, the supplier or the respondent and the appellants, they had a contract.
Exactly, and that is
And
precisely why they're not
yes,
proceeding under this rule that limits them to 12 months. They're proceeding under the contract that they had with the person with whom they contracted.
yes,
So why
please, Your
can't they
Honor,
do that?
except to say, Your Honor, that the terms of that contract are contained in the regulations, including 31(2). The contract, if the contract is outside of that, then we would have to look to see what the terms of that contract outside of the regulations are. And respectfully, Your Honor, we attempted to subpoena a contract outside of the regulations and none was provided. So therefore, Your Honors, the only contract that we are left with is the contract for the supply of electricity under Section 24. So to claim that they have come in respect of a contract that is not governed by 31(2) or any of the other regulations, we respectfully submit, Your Honor, is not permissible under the legislation. Your Honor, the Court of Appeal, if I may, came to the same conclusion. They found that there was a contract. However, and they found that the trial judge was justified in granting judgment on the basis of that contract. But Your Honors, that contract did not, or the Court of Appeal did not refer to any of the terms or on any terms that outlined or described the relationship between the public supplier and the consumer. So, Your Honors, if we look to what is in fact between the parties here, the only terms that we can distill from the exchanges of submissions, the positions of the parties, and the legislation, the only terms that we can distill are those terms which are set out in the regulations, inclusive, Your Honor, of Regulation 31(2).
I think
And
we understand your submission. You're saying that they have not proven, they have not, you subpoenaed it, they have not proved the contract, and therefore they could only have relied on 31(2). And 31(2) has a 12-month statutory bar. Does that succinctly summarize your arguments?
yes, sir, except that we were saying contract other than, or has terms other than those which are contained in the regulations.
Okay. Yes.
Yes, yes, please, Your Honor.
Yes. Thank you very much.
Yes, please, Your Honor. And an hour has passed.
Well, you're coming up against it now. It's about 2 or 3 minutes left of your time.
Yes, yes, please, Your Honor. I do not want to take the chance and in any way contribute to Justice Barrow's ill health, Your Honors. I don't.
I can condescend to particulars and tell you it was in fact a headache.
You're so gracious, Judge.
My pleasure. And I'm so grateful.
Mr. Fraser, I'm afraid you do those who sit in the court in Barbados an injustice, because they will not know what the joke is about.
Thank you very much, Mr. Fraser. Mr. Jonas, are you ready with your submissions?
Thank you very much, Your Honors. Your Honor, with your permission, I will start where my friend started in his discussion of Norweb and Justice Dyson's analysis of the ingredients in a contract and whether the arrangement between the consumer and the power supplier fell, what side of the fence it fell on, whether it was a contract or not. And Justice Borges, I am very aware of the point that you made. And with great respect to Justice Dyson, I believe that he very carefully analyzed those ingredients and he came to a conclusion, but he could as easily have come to another conclusion. Now, I believe that the importance of Justice Dyson's ruling in the Norweb case has to be considered in chronological order. The Electricity Act, which Justice Dyson was construing, was passed in 1989. The Norweb case came 6 years later in 1995. And as my friend was at great pains to observe, the legislation in Guyana under the Electricity Sector Reform Act, which was promulgated in 1999, 4 years later, was virtually identical. It took everything from the 1989 British legislation, the structure, the format, the contemplation of how the relationship would go on, that bills would be, electricity would be measured by meters and bills would issue monthly, all of that, with one fundamental exception, that faced with Justice Dyson's finding that the relationship was not contractual, the Electricity Sector Reform Act 4 years later deemed it a contract. So it avoided the unhappy result that a power supplier would have great difficulty enforcing something outside of the realm of contract, and deemed it a contract. Now, that deeming provision, Your Honor, was given a very brief reference in the submissions originally before you. And I took the liberty in the reformatted submissions, which were very hurriedly prepared on Saturday night, so I apologize for any lack of flow in those submissions. But if I can refer you, please, to page 588 of your record. I took the liberty of including a very brief extract from Benyon on statutory interpretation, Benyon being my go-to Bible in this regard. And in its 5th edition, Benyon observes in respect of deeming provisions that acts often deem things to be what they are not. An enactment may deem something to be the case when it may or may not be the case. That's where we are here, Your Honor. Justice Dyson may or may not be followed by this court. He was delving into a gray area and there is justification for his conclusion, but there are arguments against. But Ezra, the Electricity Sector Reform Act, solves our problem by saying that this arrangement, this transaction is a contract. And what is important in the deeming provision, Your Honor, is the observation of Lord Justice Asquith, which is cited at page 589, if Your Honors will just turn the page to follow me. Where the learned Lord Justice observes, and for me this is the purpose of deeming this arrangement contractual. If one is bidden to treat an imaginary state of affairs as real, one must surely, unless prohibited from doing so, also imagine as real the consequences and incidents which, if the putative state of affairs had in fact existed, must inevitably have flowed from or accompanied it. Your Honors, we have a contract, it's deemed a contract. And the single consequence of what has been deemed a contract is that we have recourse to the High Court for injunction stopping breaches, for specific performance requiring performance, and for orders for payment if the consumer goes into arrears. That is what the effect of this deeming provision is, saying that this transaction, this relationship between GPL and its consumer is contractual. Now, I heard my friend in his analysis of clause 7.5 of the standard terms and conditions. Observe the distinction which is set out in 7.5 between the bill and the quote foot of a contract, which I admit I found to be unusual language myself. Let me hasten to say, Your Honor, that my friend agrees for the first time in this forum. His submissions did not bear this out, but I am glad he's changed tack. That under the very last paragraph of the third schedule, it is provided that where there is an inconsistency between the third schedule and these standard terms, which are before Your Honor, these standard terms prevail.
Where is that?
Now, the very last paragraph of the third schedule itself, please, Your Honor. It is at page 388 of your record, paragraph 33. Wherein a license, there are standard terms and conditions regarding the matters provided for in this schedule or any other matter. The provisions of such standard terms and conditions shall apply and not this schedule.
Yes.
Thank you very much. Now, my friend made much of this distinction between payment on accounts for electricity consumed or estimated to have been consumed on his premises or on foot of a contract for supply of electricity. And in great detail, with his usual thoroughness, my friend took the court through sections 21 to 24 of the Electricity Sector Act, pointing out how the contract between the parties is created, and that under section 23, this arrangement is deemed a contract. And my friend pointed out, and I agree with him respectfully, that many of the terms of that contract, and I believe that this board also made that observation, will be implied by virtue of the regulations and the standard terms themselves, so that there is much that will be implied into the contract by operation of law, as a matter of what the terms of these standard terms are, and where the standard terms are silent, the third schedule itself. However, my friend did not go on, as I ask Your Honors to do, to consider section 29 of the Act. Section 29 is at page 330 of your record. And section 29 provides that once the Public Utilities Commission agrees in special circumstances, GPL can create a special contract with a special consumer. Now that, of course, has to be carefully managed, because fairness and equity and all of those things will require that we all pay the same rates. So if I'm a residential consumer, I must pay the same rates per kilowatt hour as other residential consumers. So special contracts must get the sanction of the PUC. That is well and good. But here is what I believe, with great respect to my friend, that he missed. Among the terms that are implied in the Section 23 contract are, you get a meter. The single pillar, you have to safeguard your meter. You can't blame somebody else if they're tampering. You got to safeguard it. The meter is read so that it measures your supply of electricity. And every month, you get a bill, and you're obligated to pay the bill in full. But under this Section 29 special contract, you might not get a bill at all. There might not be a meter at all. Once the PUC satisfies itself that the circumstances in Section 29 are appropriate, you might pay a flat rate every month for 12 months for a year. So no meter, no bill, but you are obligated to pay according to your special contract on foot of the contract. And it's my respectful view, Your Honor, and my respectful submission that this is what the standard terms and conditions are talking about when in paragraph 7.5, they follow the language of the Section 23 contract and all of the implied terms, which say on your account, you got to pay for everything. And the account is dealt with elsewhere in the standard terms, and I will address that. But that account speaks to the account that the public supplier might bill you monthly, might estimate bills if they can't read the bill, might decide there's been meter interference and attach an estimated bill, and all of that goes onto the account. And every month, you receive a bill on that account, and you're obligated to pay that bill in 21 days. But alternatively, if you have a special Section 29 contract, you must pay what you are owed on foot of that contract. So I believe that that is what the language speaks to in Section 7.5 of the standard terms, which of course take precedence over the third schedule, where they make provision for matters referenced in the third schedule. Now, if I'm right about that, please, Your Honors, then I will not belabor the point that I think is of fundamental importance, that the statement of claim which was filed before the judge at first instance very specifically pleaded that the defendants were customers and consumers of electricity supplied by the plaintiff under an agreement, and that tariffs payable, I'm sorry, Your Honors, I'm reading from page 192, where the statement of claim can be found, and that tariffs payable are fixed by the Act, and consumers are billed in accordance with such rates monthly on a running credit account for electricity consumed by them, as measured by a meter installed at the premises of the consumer and through which electricity is supplied. The agreement is again referred to and the implication of its terms by the Act at paragraph 4 of the statement of claim. It's a term of the agreement implied by the Act and specified in the license. And then reference is made to the statutory obligation in that same clause 4 that the defendants to whom electricity is supplied are liable to the plaintiff in accordance with those tariffs for payment of accounts for all electricity consumed or estimated by the plaintiff to have been consumed on their premises or on foot of a contract for supply of electricity. So there are two self-standing, independent causes of action which exist here. The first is founded in the contract, which is deemed a contract by Section 23. And the second is the statutory debt which is created by the issue of the bill under clause 7.5 of the standard terms. That bill creating a statutory debt which itself also founds a cause of action, which GPL can come to the Superior Court of Record to enforce. Now, at page 123 of your record, in submissions before the Court of Appeal that was put in May 2021, at paragraph 7, reference is made to Halsbury's Laws of England. Volume 8, 3rd edition, paragraph 448, statutory debts, where an act of parliament creates an obligation on any person to pay a sum of money to any other person, the amount due can be recovered as a debt by action where no other remedy is provided and where no provision to the contrary is contained in the act. Where no provision to the contrary is contained in the act. So we have two standalone causes of action. And from 1999 to 2010, the public supplier, if it found that you ran up arrears on your account, sending you monthly bills and you don't pay them all and you run up arrears, can claim against you in court for breach of the contract and for this statutory debt. I'll ask you honest to observe that in that case, there's no back billing. If I am receiving monthly bills on an account and I'm not paying them in full, the accrual of my debt has absolutely nothing to do with the concept of back billing, which is confined both in the third schedule and in the standard terms to a situation where I am not billed for a period of time, or I am underbilled for a period of time because of meter interference, because the meter was defective, because the power supplier couldn't go to read the meter because the gate was locked. And they estimate and then they back bill you for a period of time. But where I'm receiving monthly bills, and those bills accrue because of insufficient payments, that is not back billing. That is just an accrual of a debt. So, Your Honors, in 2010, an amendment is made to Schedule 3. And what I'd like to respectfully point out, please, is that the regulatory framework tries to be as comprehensive as possible. I'll just confine my observation, please, to the license itself. In the license, if I can refer you to 7.2, please, of the license. I'm sorry, to 6.3 of the license. This is at page 430 of your record.
Four three zero.
Yes, please, of your record. The license talks about installing this meter and your obligation to keep it safe. And then under 6.3, it says that the company can test the meter from time to time. Of course, makes sense. It says that if the meter has been tampered with, the customer must pay the cost of repairing it, which of course again makes sense because it's the customer's responsibility to safeguard it. A situation may arise, this is the next paragraph, please, where the customer says, my bill looking high, and can ask the power supplier to check it. And in that case, if there's no tampering and it's fine, it's binding on everybody. But if it is outside a range of plus or minus 2.5%, the public supplier must fix it and go retroactively for the past 3 months to correct any differences. So every single scenario is contemplated as far as possible in an attempt to make this statutory framework address every single conceivable situation that arises. What happened, Your Honors, is that there's one situation that I did not find addressed in these rules. And that situation dealt with a person who is not a consumer. So a person who had no Section 23 contract with GPL. You see, it's well and good if that person failed to safeguard their meter so that somebody tampered, or that person took too long to ask GPL to fix it, or that person locked the gate. It's well and good to hold that person responsible. But what happens when there's no contract, there's no GPL, the power supplier, finds that electricity is being supplied to premises, but there's no consumer there. There's nobody with whom it has a contractual arrangement. What happens if it finds power supply to premises and the registered consumer has been dead for the past 15 years? Certainly, this contract must be a personal contract that terminates upon the death. Because one of the things the consumer has to show you is that he's got title to the property, so you're not trespassing when you go on the property to connect him. So this was a lacuna in the framework. And for that reason, the Prime Minister, who at the time had responsibility for electricity, introduced this amendment to Regulation 31. Now, my friend has made much of it, but I would like again to ask Your Honors to consider the chronological sequence of events. All times up to 2010, GPL had a contract, GPL had a cause of action under that contract, GPL had a right, an independent cause of action, to claim under a bill where that bill was not paid, because 7.5 said consumer has an obligation to pay the bill. My friend is seeking to persuade the court that in 2010, an amendment was made to take away all of those rights, to take away all of that. By this amendment in 31.2. But I will ask Your Honors, please, to consider the language in 31.2. What I've noticed is that the starting point in cases referred to by the appellant to try to suggest that the public supplier is confined in any litigation to 31.2 does not support the contention. Barco and Brown, Wilkinson, Passmore, Wolverhampton, they all take the position that you construe legislation. And in modern times, where we know that legislation is drafted by professionals who are skilled in the technical aspects, you more comfortably have resort to construing the ordinary language of the legislation to get the inference of what it is that Parliament requires and wishes. So it's no longer just safe to say, if Parliament provides a liability and provides a remedy, that's the remedy you gotta adhere to. You now construe the legislation. And again, I took the liberty in my submissions before Your Honor to cite Halsbury's third edition on that point. What I've noticed is as we move to more recent times, Halsbury's is much more reticent about saying there's some general rule that you're bound by the remedy provided. And Halsbury's is much more careful to say, look at the legislation and see what the intention of Parliament is. In that regard, please, may I refer you to paragraph 21 of my submissions filed the day before yesterday. And again, please, this is the second, and it was only the two occasions that I took the liberty of adding material that was not there previously. Your Honors will see at paragraph 21 at page 593 of your record. I cite 36 Halsbury's Laws of England, third edition. I will get to the fourth edition shortly. Statutes creating a new liability and prescribing a remedy. That's in bold in Halsbury's. And it says, where a new obligation not previously existing is created by a statute at the same time, which at the same time gives a special remedy for enforcing it, the initial general rule, please note the care in that language, the initial general rule is that the obligation cannot be enforced in any other manner. The question is, however, and I believe that is where we are, Your Honors, one of the true construction of the particular statute concerned, and it may be the intention of the statute as disclosed by its scope and its wording, as adverted to by Justice Anderson during my friend's submissions, that other remedies should not be excluded. Your Honor, this morning, and again, I ask Your Honors to forgive me and allow me just a bit of latitude, because Your Honors will observe that 4/5 of the grounds of appeal were deleted, and I am now focusing on 1/5, what previously was only 1/5 of my argument. But this morning I looked at the fourth edition of Halsbury's, the corresponding section. And the general rule is even more softly referenced. It's not on your record, and I'll ask Your Honors for permission just to read it, which I will do as clearly and carefully as I can. As a general rule, it may be said that where a statute itself provides a remedy, there is a prima facie presumption that that remedy is intended to be the only one, but this presumption will by no means always prevail. The question whether the statutory remedy is exclusive or cumulative with other existing remedies depends in each case on the construction of the statute concerned, and it is often not an easy question to answer. Your Honors, in the case that bar I respectfully submit, it is an easy question to answer. You see, after 11 years, the Electricity Sector Reform Act was promulgated in 1999. And after 11 years, when this lacuna in the overall statutory framework seeking to avoid theft of electricity and create civil and criminal liability for people who are stealing electricity, who are damaging infrastructure, when it was discovered that if you find somebody in a house and you don't have a contract with them, you can't say that they're converting your electricity, because electricity is not a chattel reel. It's not capable of conversion. You can't say they're guilty of conspiracy to defraud, because they might be acting all by themselves. There's no conspiracy. You have a difficulty, but you have even greater practical difficulties if you want to claim compensation from them, because you don't know how long they've been in the premises. They might have been there last month, or they might have been there for 10 years. So in your quantification to assess how much electricity they have stolen, the public supplier's case is impossible. You don't know if they bought that fridge last month and the microwave the month before, or if they've had them for 10 years. So in your quantification of day-to-day kilowatt consumption, your burden of proof is impossible to achieve. And therefore, it was necessary to fill the gap in the legislative structure in the way that Parliament did, that the minister with responsibility did in 2010. But he was very careful. He did not want to take away the public supplier's pre-existing rights to access the court to get remedies for the obligations which were created. And therefore, he started his conversation with the words, without prejudice to a public supplier's right under any other provision of the Act, these regulations, or any other law or legal principle. So what you got, keep it. If you have access to court, keep it. If it's a contract and you can go to the High Court, you can still go to the High Court. If there's a statutory debt created, there's still a statutory debt enforceable by a superior court of record, without prejudice to any of that. And Your Honors, at page 593 of your record, I have cited the decision of the Privy Council in Attorney General of Trinidad and Ramanup, 2005, where a similar expression was considered in the legislation. That is at page 593 of your record, please. And their lordships were directed to section 14, which provides for the removal of doubt. It is hereby declared that if any person alleges that any provision of this chapter has been, is being, or is likely to be contravened in relation to him, then without prejudice to any other action with respect to the same matter which is lawfully available, that person may apply to the High Court for redress. And their lordships viewed the matter as follows. Section 14 recognizes and affirms the court's power to award remedies for contravention of the Constitution. The jurisdiction is an integral part of the protection chapter of the Constitution. It is an essential element in the protection intended to be afforded by the Constitution against misuse of state power. Section 14 presupposes that by exercise of this jurisdiction, the court will be able to afford the wronged citizen effective relief in respect of the state's violation of a constitutional right. And finally, this jurisdiction is separate from and additional to, quoting the words without prejudice as set out in the section, all other remedial jurisdiction of the court. Without prejudice to all other remedial jurisdiction of the court. In 2010, a new provision was introduced, not, as my friend is suggesting, to restrict and create the absurd result that although I can bill you retroactively for 24 months, when you don't pay that, I can only come to court for 12 months. Not to create that absurd result.
Mr. Jonas, can you just think about this for me? I'm not sure what the answer will be, but I understand what you've been addressing us on, and you're saying that the amendment did not seek to take away the rights of the public supplier to sue in contract. But I wondered whether could you have brought a claim in these circumstances under, is it Regulation 31.2?
Your Honor, I don't think I could have. And I'm grateful for that question, and I will try as best I can with my limitations to answer it. You see, my friend made much of the definition given in Section 21 of the Act of a consumer. A consumer is a person that enters the Section 23 contract, and a consumer is the owner of the premises that the electricity is supplied to. So Che Jiangping and Guo Zhangguo are consumers. They got a contract, and we're supplying them to their premises. But if Your Honor has regard to Clause 31, subsection 2 at page 408 of your record, Your Honors will observe, as my friend says, everywhere subsequently in the Act, the word consumer is used because in Section 21 they say hereinafter referred to as consumer. Section 31 does not refer to consumer. Section 31 says any person. Without prejudice and all of that, a public supplier may recover in a civil action from any person over 18 who is occupying the premises where we find this electricity being used. Your Honor, this subsection, it is my respectful view and my respectful submission, was introduced to close that gap where there is no cause of action outside of the consumer, outside of the contract and the statutory obligation to pay a bill. But GPL goes in and finds that grandma died 10 years ago, and this grandchild is living here consuming electricity but has no contract. What do? We have no cause of action. And this is designed to fill the gap by saying, don't worry about how the time frame that this unknown person was there. We will treat it as 12 years. And don't worry about the fact that the unknown person might say, I didn't have all that equipment last month. I only just bought it. The consumption previously was much lower, because the subparagraph 3 spells out that you audit the appliances, you measure the difference, you calculate it based on any other procedure. So it tells you how to quantify what this person has to pay. And then it creates a new cause of action enforceable in the magistrate's court, which it treats as back billing. And again, that word back billing is in subsection 2, a back billing period of 12 months. And it says, against this person with whom you have no contract, you now have a right to a civil action in magistrate's court. And this, please, Your Honors, this 31 subsection 2 is akin to the provision which was discussed by the president of the court in Small and Saul, where the single section, the expression they used I'd never seen before, uno flatu, the single section in the act in Baraclough and Brown said that if you sink a ship, the undertaker can go and collect that ship, and you have to pay him his cost by an action in magistrate's court. In a single section, uno flatu, the obligation was created, and Parliament told you where to go. Similarly here, the obligation is created which did not exist before, that a person with whom the public supplier had no contract now becomes liable in a civil action for 12 months based on an audit of the appliances as done by the public supplier. And in the same action, in the same section, it says you go to magistrate's court. Now,
I understand you, Counsel, but just to take the most extreme case, so there is a contract, there is a consumer, and then the consumer rips out the meter. So there is no meter by which one can do the regular billing. You're saying that that still does not convert that contractual situation into one covered by 31(2).
no, please, sir, I do not believe it does. Your Honor, let me rephrase that. It may be that the supplier chooses to go under Section 31.2, but I do not believe that he is exclusively confined to 31.2. And the reason for that is that under the standard terms and conditions, if the public supplier finds its consumer, its contractual party, to have been tampering, even if they used a sledgehammer rather than something more dainty, so they hit the meter out and you can't read the meter at all, the public supplier is empowered to estimate the consumption of electricity retroactively for 24 months and to include it on the account of the consumer. So it goes on his account, it goes in his next bill, and he is statutorily obligated to pay that bill, which is a debt, within 21 days of its date of issue. So, Your Honor, I can see that under 31.2, the public supplier might say, all right, you're a person and I will claim against you with 12 months limit. But I don't think the public supplier is confined to that. And I don't think that Section 31.2 is designed or intended for that, because the public supplier has, under the standard terms and conditions, a very happy result. He estimates and he bills, and Section 7.5 says that the customer is liable in respect for payment of accounts for all electricity, both consumed and estimated to have been consumed. So once that estimated sum goes on your bill, the statutory debt is created, and it is an implied term of the statutory contract that you got to pay it. And access is had to the High Court to recover that sum. I
Okay.
believe that I'm sorry, sir.
No, I was just thanking you for the explanation. Thank you.
Thank you, sir. So I believe that the intention behind 31.2 is to enlarge the ambit of liability, the group of people, the categories of people who are liable, who can potentially be liable. But it certainly is not intended to confine the public supplier, who always had recourse because the contract is deemed to be a contract, having learned the lesson from Justice Dyson in the Norweb case 5 years before. I don't think the intention was to come full circle and confine him again.
Remind me again,
Yeah.
which is the provision that speaks to 24 months recovery?
Your Honor, in my submissions, a number of scenarios are described. It is at power page 590. And this is the scenario at C. Now, the scenario at C refers, Your Honor, to paragraph 16 of the third schedule. But, Your Honor, it is also the case that the standard terms and conditions provide for, at page 431 of your record, that provision that is in 16.3 of the third schedule, which says that the public supplier can retroactively bill for 24 months based on an estimate.
Yes.
It is also provided in the standard terms, which of course take precedence at page 431 of your record. It is the second to last paragraph before clause 6.4. It says, in the event of unauthorized
interference, yes.
Yes, please, sir. Now, Your Honor, will note the language unauthorized interference. It doesn't say if the consumer tampered. The obligation on the consumer is to safeguard, and therefore it is not open to the consumer to say a third party came unknown to me in the middle of the night and tampered with the meter and I benefited. He has breached his obligation, and therefore in the event of anonymous unauthorized interference, I can back bill for 24 months based on my estimate of your consumption. Your Honor, I wonder if, I know I haven't taken an hour, and I feel that
Don't feel
omission.
compelled.
I wonder if there's anything else I can assist with. In that case, Your Honors, I will save Justice Barrow's head, and I will ask Your Honors to permit me to close.
Yes. Mr. Fraser, is there anything you wish to say in response?
May it please Your Honors, in the email that we sent on Friday afternoon, we had asked the court's leave if Ms. Scott would be able to reply to Mr. Jonas's submissions.
Yes.
Yes, we had assumed that leave had been granted, Your Honor.
Yes, please proceed, Mrs. Scott Lal.
This would be in accordance with the case management order that the reply is 15 minutes.
But of course, Your Honor,
With you, Mr. Fraser, I don't take things as they may otherwise appear. Continue.
Mrs. Lal.
Your Honor, that's why I asked Ms. Scott to do the reply.
Yes.
May it please you, Your Honorable President Saunders, Honorable Justice Anderson, Honorable Justice Rajnath Lee, Honorable Justice Barrow, Honorable Justice Burgess. By way of reply, we respectfully disagree with the respondent's first submission that Section 23 deems the transaction between the consumer and public supplier a contract simpliciter. Your Honors, the terms of Section 23 specifically states that the acceptance upon the notices and the acceptance of the notice, it shall constitute a contract for the supply of electricity in accordance with the Act and the regulations. It is our position that insofar as those terms and conditions are imposed by the Act rather than voluntarily undertaken between the parties, then the contract is not of it is a contract, but it is a specific type of contract, and we submit is a statutory contract because it is not of a purely contractual character. Insofar as, for example, the tariff, there is no leeway there for a waiver or discussion or negotiations in relation to the tariff. It is imposed by the statute. Your Honors, we were at great pains to find this a case that deals with this type of contract. And in the preparation of the reply, Your Honors, we did come across one case, a 2020 decision from the Supreme Court of India. But Your Honors, I respectfully seek your leave on whether I can refer to that decision.
You have sent it to Mr. Jonas?
No, please, Your Honors.
Really?
Your Honor, we do believe it would be of great assistance, and we would ask as well permission if we can put it up on the screen.
I want to tell you that for myself, I think that it's quite unfair, and I would be disinclined to allow it, because it's not fair to Mr. Jonas. We would have no opportunity to hear from him as to what would be his response to what you are relying on. But I'm speaking for myself, and I am not.
No, that's you know, a norm. How long you had this authority?
Your Honors, we only came across it this today when we were trying to unearth a decision that may be of assistance. Your Honors, I'll be guided by the court and I will move on.
Yes, go ahead.
Thank you, Your Honors. Your Honors, our submission in respect of the statutory character of the contract is based on the fact of there not being that voluntary obligation, that obligation that is voluntarily undertaken, but is imposed by the statute. And it is because of that nature We secondly disagree with the submission by the respondent that the public supplier had a cause of action in contract. We say that insofar as what the public supplier has sought to sue upon is a statutory obligation, the liability for which is imposed, and in this case, under clause 7.5 of the standard terms and conditions, then and is not in respect of an obligation that has been voluntarily undertaken by the parties, then the principle of contract law do not apply. Your Honor, if that position is to be maintained, it will then allow the public supplier to have the benefit to say, I am not coming under the regulation 31.3 because it's without prejudice. I can ground my claim in contract liability, but I'm basing my suit on a statutory duty to the detriment of the consumer who is not so similarly positioned. And if I can ask for some latitude, Your Honors, to demonstrate this by reference to the case of Bahamas Electricity Corporation and Carnival Leisure Industries. It is it's referred to at paragraph 7 of our adjusted submissions, page 607 of the records. Your Honors, in that case, the public supply, there was a contract for supply of electricity similar to our section 23, contract for the supply of electricity. The public supplier sued for payment of electricity that was under-recorded. The consumer then came to raise the common law defense of estoppel by saying, you have presented me this bill and you represented to me that this is what I owe. How can you then come back and say that I owe you for under-recorded consumption? The High Court of the Bahamas, whose decision was upheld by the Court of Appeal of Bahamas, said that the consumer did not have that defense, that common law defense of estoppel, because what was being sought to impose was not a voluntarily, it was statutory, and the parties can't waive those obligations. They're imposed by the statute. We, Your Honors, made attempts to unearth the Court of Appeal decision, but we were unable to so do. The matter was appealed to the Privy Council. However, the findings of the Court of Appeal in respect of the issue of estoppel was reserved by the Privy Council because it was not pursued, although they did refer to it in passing to the extent that that issue was not being pursued by the appellant, by the consumer. And so, Your Honors, we ask Your Honors, and as for that reason, Your Honors, we sought by that demonstration to demonstrate to the court that insofar as the liability is grounded on a statutory obligation, it's not contractual where we have negotiated that specific term which you are suing me for. And so it would be of great disadvantage to the consumer who cannot come and raise a common law defense of estoppel, who cannot come and raise the common law defense of waiver of repudiatory breach, or the common law seek to say, but you didn't mitigate your loss. You you saw that I was in default, and you nevertheless kept supplying me electricity for years and years and years. And so I cannot ground those because of the very fact the nature of the suit is statutory. It's a statutory obligation that the public supplier, on the other hand, can say, but I have brought my claim also on the statute, and that gives me an independent cause of action. With the greatest respect to the respondent, Your Honors, we most respectfully disagree. And Your Honors, the courts have always been steadfast in the response to the relationship between the powerful party and the weaker party, and here the weaker party being the consumer. Thirdly, Your Honors, in respect...
Counsel.
Yes, please, Your
Your
Honors.
submission seems to be pitched very, very much on the notion of lack of equal bargaining power and unfairness in negotiating if there's any, or the fact that there is no negotiation, etc. Are you saying that these factors make a contract unenforceable?
No, please, Your Honors. We're saying, Your Honors, most respectfully, that if we are to categorize this statutory contract at the same level of an ordinary contract, and I am seeking to enforce a statutory obligation, then that creates some unequalness, because the consumer may not be afforded to where he may otherwise have had a common law defense.
All right, hold on. It creates some unequalness. I gather that very clearly. But
Yes,
so what
please.
is the consequence of that? Does that vitiate the contract? Does it mean that there is no contract?
Your Honors, there is a contract,
Okay.
but it is a specific type of contract.
Well, it's a contract which is founded not upon the parties signing a document saying, I accept the terms stated above, etc., but rather a contract which the law says, you are getting a supply of electricity and these are the rates at which you will pay, etc., etc. You'll get the... So there is the statutory, as it were, furnishing of the essence of a contract, obligation to supply, obligation to pay. Surely there can be other things as well.
Yes, please, Your Honor. But insofar as you're coming to enforce, you can come to enforce, there may be aspects of that contract which falls within contractual obligations that are voluntarily undertaken.
No, but with respect, why does it have to be voluntarily undertaken? This is what I'm trying to get clear. Even if it is statutorily imposed, it is a contract. You have called it a contract. You accept it's a contract. I understand what you're saying, you know, that it was entered into upon the basis of unequal bargaining power, etc. I understand that. But you've accepted it is still a contract. So the fact that it was entered into by parties of unequal bargaining power, what makes it not enforceable as a contract nonetheless?
What makes it not enforceable as a contract is because of the very fact that those contractual common law defenses that you may have may not be available because of the very nature of the statutory duty.
But with respect, I mean, that is hypothetical in any case. We do not know that they are not available. But let us say hypothetically they are not available. Was there any attempt to rely upon them in this case and they were shut down because of the special nature of this contract? I didn't get that impression.
No, please. None of those defenses were relied in this case.
So leave them out. So what you have here, as I understand it, in terms of your argument, is a contract. It was a contract which was founded upon statutorily imposed central terms, and then there were other terms added by the terms and conditions, etc., etc. So how do you get past that?
But on another basis, GPL is a monopoly, isn't it?
Yes, please, Your Honor.
So that they could set their terms, even without the statute. And you either contract with them on their terms or you generate your own electricity. Xi Jinping was fully entitled, well, I don't know, maybe the statute might have prohibited him from generating his own electricity, I'm not sure. But the impression I'm getting from what you're saying is that a monopoly has problems enforcing the contract because they just set down their terms and you can't bargain with them.
Your Honors, the section, if I may, the section 23, insofar as it states that the contract shall be in accordance with the terms of the Act, then we don't believe, most respectfully, Your Honors, that the public supplier can waive the terms as set out by the tariff, for example, and that takes you back to the Public Utilities Commissions Act, where if the supplier tries to change the terms, you can go to the Public Utilities Commission, you can launch your complaint there, and that what we say is, though it is the contract, it is of a different character because all that the agreement does is bring to the attention of the parties that these are the terms as these are the tariffs as per the Act, which governs not only the consumer, but the Act governs the public supplier.
Okay, we understand the point you're making. Is there anything else?
Your Honors, I believe my time is up.
Yes, but we'll allow you 2 more minutes to wind up if you wish.
Grateful, please, Your Honors. Your Honors, very quickly, in response to the interpretation of the respondent of Regulation 31.2, we respectfully disagree. It is not limited to stealing. There are several instances there that is addressed within the Act. Under Sections 5.1 of the Interpretation and General Clauses Act 2.1, it states that where the words or other or otherwise is used, then it should be construed disjunctively and not implying similarity. And so, for example, where in the statute, in Regulation 31.2 states that it's or otherwise used, it is not to be so construed similarly to stealing, where there is, for example, stealing or there's diversion. Further, under Clause 7.5 of the Standard Terms and Conditions, it speaks to consumption without the contract and consumption in terms of a contract for supply of electricity. And so, further, in all of those instances, the contract for supply of electricity can arise. Where there is that contract for supply of electricity, there may be that meter interference, where under Clause 6.3 of the Standard Terms of Conditions at page 431 of the record, where it says that they can retrospectively bill for 24 months, which is in line with Regulation 31.2, which sets out you can back bill for 1 year unless otherwise provided for by the Standard Terms and Conditions. So there is no inconsistency between the Regulation 31.2 and the Standard Terms and Conditions. Okay. In closing, Your Honors, we respectfully submit that if Your Honor accepts that there is no cause of action in contract, then we ask the Honorable Court to consider what was claimed. It has all times been for electricity consumed under Clause 7.5 of the Standard Terms and Conditions, The claim was brought on the 29th of October 2010, and that's at page 191 of the record. The Public Electricity Supply Amendment Regulation was passed on the 3rd of August 2010, and that is at page 411 of the records. It was later affirmed on the 14th of October 2010. And so at the time when the claim was brought, the only thing that they can come if the court agrees that the contract is excluded is for that civil action for electricity consumed. We do not believe it was the intent of the legislatures for the public supplier to having created that mechanism for recovery in the civil action, and for the supplier to do the very thing specified by regulation 31.2 to say that they fall outside due to the without prejudice words, when what they have come for is exactly what is prescribed by regulations 31.2. Your Honors, unless there's anything I can assist the court, those are the extent of our submissions.
Okay, thank you very much, Mrs. Scott-Lal. So that concludes our proceedings in this matter, and we're thankful to counsel. We will reserve our decision, and we will let you know when it is ready for delivery. Yeah, yeah. That concludes our sitting in Barbados. Once again, I wish to thank Chief Justice Sir Patterson, the registrar, the entire staff of the Barbados Judiciary, the police service, and all the various agencies that have made our stay a very appreciated one. We certainly look forward to coming back to Barbados to sit sometime in the future. And of course, between Wednesday and Friday, we have the Academy for Law, which will be hosting its criminal justice reform conference at the Hilton Hotel. And we certainly invite those who can attend to do so. Madam Registrar.
All rise for the President and judges of the Caribbean Court of Justice.